Brynelson,
Present.
Fleischman,
Here.
Hamilton. Okay. Hamilton, you're on mute. Hamilton? Calling the roll.
All right, I have the double mute. Present, I apologize.
Hartston,
Here.
Shining,
Here.
you.
Here, thank you.
Thank you.
Okay, great. Today we do again have a number of folks who've been invited to speak, including 2 from out of state. So I'd like to follow the pattern we've set in a couple of their meetings, hearing from our invited speakers first, and then moving to public comment, starting with our out-of-state guests, and actually starting with our Supreme Court Justice out-of-state guest. So hopefully that's okay with the group. I did ask, I think between myself and Linda, asked our invited speakers to focus on that key question that you all were grappling with last time around creditor or collection agency harassment, and whether or not it would be appropriate to include in the paraprofessional program, given in particular the federal law overlay. And so I'd like to start off with Justice Dino Jimenez from the Utah Supreme Court. Thank you so much for joining us. If you could just share with us a little bit about the thinking around this issue with respect to the Utah Paraprofessional Program, that would be wonderful. Thank you.
It's my pleasure, and thank you for having me. Also, let me just open myself up to questions from the very beginning. I much prefer having an open dialogue than just lecturing. For me, this is not a difficult question. I think that you have to start with the notion that even if something is complicated, right, there is no support for the notion that a lawyer is better able to handle it than a paraprofessional or a legal professional that spends their time working in the particular area. That's just, that seems to be, you know, just a bit of, frankly, a bit of misinformation. I mean, I practiced law for a long time. I did complex commercial litigation before I went to the court. I had no business doing, after 15 years, for example, a divorce case. But a paralegal that had been working in the area for 15 years could easily handle, much better than a lawyer, something that is very, very complicated. Frankly, more complicated than debt collection, and more complicated than debt collection, including the federal and state overlays of consumer protection law. And it's not something that I'm just saying, right? There have been landmark studies done that document this. In particular, there's a landmark study that was done in the UK. And if you're looking for a reference, Rebecca Sandifer, who, by the way, is probably the most widely regarded and respected individual in the access to justice sphere in the United States, has recently published an article in the Stanford Journal of Civil Rights and Civil Liberties. And she really takes on this issue of paraprofessionals versus lawyers. And she specifically cites to this study. In this particular study, in England, these individuals who are not solicitors are giving legal advice in debt collection, landlord-tenant, family law matters, healthcare matters, and then they're being ranked against solicitors that are giving advice in the same areas. The study found that the rate of error or dissatisfaction was the same for both paraprofessionals, or non-solicitors in that case, and solicitors. It was about a 20 to 25% error rate, if I recall correctly. The stunning part of the study was that the consumer ranked the non-lawyer, the non-solicitor, 6 times, 600% more likely to be ranked excellent than the lawyer. Right? And it's not as a surprise if you think about it for a couple of reasons. One, that's really what they do, right? Invest in that particular area and have that kind of expertise that even somebody like us, I mean, they've gone to law school, practiced for a long period of time, may not know. The second is, right, that these individuals are charging, in those cases, charging less money. So when you combine the two, right, their consumer satisfaction goes up. Second, if you do start limiting the ability of paraprofessionals to practice in these areas, you kind of cripple them in a way, right? I think that's really important to understand. What you want to do is remove barriers and make these services as widely available as possible. Why? Because you're benchmarking it to what? To zero, right? Most respondents in California in debt collection actions, like most respondents in Utah in debt collection actions, are represented exactly 0% of the time. I think in Utah, it's officially less than 1% of the time. And I'm certain it's no different in any other jurisdiction. It's just incredible, right? And frankly, it's not worth it, right? 75% of all matters, civil matters, not just debt collection matters in the United States, are worth less than $5,200. So it doesn't make sense to hire counsel. So what are we're saying that unless these individuals could get a Mercedes, basically a lawyer, they should get nothing, right? The Toyota would not be okay in these particular cases. That's just fundamentally wrong. And those are really the two points that I want to drive home. The importance of benchmarking and the fact that the data simply doesn't support the notion that paraprofessionals or non-lawyers are just less able to provide advice in these areas.
Steve and Fleischman, I see you have your hand up.
Your Honor, thank you very, very much for joining us. I'd like to give you some background and seek your input on an issue. First, with respect to what you said about ordinary collection actions, another subcommittee of this committee has preliminarily recommended that paraprofessionals could defend debtors in those types of actions. What we're struggling with now are affirmative claims by debtors for harassment by creditors or collection agencies.
Understood.
Okay, and there's a federal statute and there's a comparable state statute. We have also come to the conclusion that as a body of the California State Bar, we have no authority whatsoever to allow paraprofessionals to practice in federal court. So federal court is off limits. And that was based in large part on an opinion letter from the General Counsel of the California State Bar.
Of course.
So here's the issue on the table that we're struggling with. If we allow paraprofessionals to practice in this area, they would not be allowed to sue in federal court under the Federal Act, or if they sued in state court and alleged a claim under the Federal Act, that case could get removed to federal court, in which case the paraprofessional could no longer represent. Now, someone else on the committee has pointed out, and I think he's largely correct, that the California and the federal acts are more or less parallel, and that substantively you may not be giving up much by not allowing the paraprofessionals to allege federal causes of action. But what you're giving up is the venue issue, the right to be in federal court. And I said this last time, and I'll say it again, I've got nothing but the utmost respect for California state court judges, but there are times where in cases you want to be in federal court and sometimes you want to be in state court. And so that's the issue we were struggling with last time. And I'm wondering if you could give us your thoughts on that. And Amos, that was a good faith attempt to try to summarize your position. I hope I came close.
It's a great question. And we're not going to say anything different, right? So here, you're absolutely right. I mean, they can bring the counterclaim, whether it's under the California or Utah, mini provision or under the Fair Debt Collection Practices Act. They can bring it in state court. And sometimes it's going to stay in state court. Typically, if I'm a plaintiff, I'm going to prefer state court. I don't know what it's like in California. For example, I only need 6 out of 8 jurors in state court versus a unanimous 12 in federal court. When I was practicing law, I'm quoting myself back then, I'm not quoting myself now, I used to tell people it was malpractice for a plaintiff's lawyer to bring an action on behalf of a plaintiff in federal court because of that. But I take your point that it's still, there may be times where you don't want to give that up. And the paraprofessional needs to know that. So in Utah, what we've done, I mean, to separate that out, right, you've imposed ethical obligations, and they need to understand those ethical obligations. And if they don't inform their client of the fact that they ought to be in federal court, if they don't make the referral to the lawyer, then they're subject to liability. But what I fundamentally deal with or disagree with is just this carte blanche. No, because some of these cases might or should be in federal court. Therefore, they should never be allowed to represent anyone in state court. And I keep coming back to the benchmark. What are they really getting? Which is zero in most of these cases. So because one or two of these people may end up having a lawyer who should be in federal court, we're going to deny the vast majority of these folks the right to participate with a representative in state court.
Well, again,
yeah.
In a straightforward collection action by the bank against the consumer, we've already said the paraprofessional can participate in that, at least preliminarily. So I suppose we're talking about the counterclaim, and we're talking about the affirmative action to seeking redress under the federal or state statute. You know, I don't pretend to know what practice is like in Utah. In California, we have large cities, and we have what the late great Jim Roby used to call cow towns. And if you represent a plaintiff in a cow town up in Northern California, you may want to file in the Northern District of California and have your case tried in San Francisco or Alameda rather than in a small county. The jury pool will be very different. That could work to the advantage of your client or not. What I'm struggling with is the idea that a client who goes to a paraprofessional for those affirmative claims will not have the same rights that if they go to a lawyer.
That's where I just don't understand that. Of course they do. The paraprofessional may not be able to represent them. So they can go to the paraprofessional, and the paraprofessional is ethically obligated, in the case you've said, to direct them to a lawyer for those claims. This underlying assumption that they're not ethical or that they won't be trained in that, we have a complete separate ethics exam, right, and course to indicate to them, these are things, right, and these actions that you may have to turn over to a lawyer. And it's one of the reasons, frankly, that we've been talking to lawyers about the benefit of cooperating with the paraprofessionals, because they're going to feed work up to the lawyer as well, right? This is a case, for example, they've gone to a paraprofessional. The paraprofessional has been able to identify the fact that there may be a federal, Fair Debt Collection Practices Act claim, but they can't do it. Now they can refer it up to the lawyer. So the lawyer is going to make money in that particular case. In other cases, that paralegal will be able to represent them in state court and make the same arguments. I mean, it really comes down to an ethical issue.
So
If I could, go ahead.
Yeah, Carolyn has her hand up.
So I have, thank you, Your Honor. Thank you so much for being here tonight and taking your valuable time. And I know you've been very involved in this. And again, thank you for your public service in this with regard to Utah. I understand that that there's 3 areas. There's family law, unlawful detainer, and debt collection. Yeah. And but my super simple question is this: has there been any discussion in Utah about the confidentiality of communications between the paraprofessionals and in their milieu when they're talking about with their clients, and that it might go somewhere else? Is there any change in the law or legal?
They're treated. It's treated as if they are a lawyer. The same lawyer-client restrictions. Carolyn, we're rewriting all of the laws around the LPPs right now to incorporate them into the lawyer regulations. We're saying that a lawyer includes a legal professional unless specifically designated otherwise. So those same issues of confidentiality, those same core responsibilities that the lawyer would own, the paraprofessional owns to the client, and those same rights that the client has, including the privilege, for example, attached to the lawyer or to the paraprofessional.
Could I offer something here?
No, I'm sorry. I know you're one of our other presenters, but we do have a sequence for the presenters. I do want to make sure we hear from our Arizona representative first. Okay. Are there any other subcommittee members that have I don't see anybody else with a hand up for Justice Jimenez.
Could I make one more question, Leah?
Yes, go ahead.
Your Honor, what I know about the Utah program simply lists consumer protection. Would these types of claims be permissible under the Utah version? I see you nodding your head yes.
Yeah, in my view, absolutely. But in my view, as we pointed out, if that's a conversation that the individual needs to have with the client, and there needs to be a decision made about whether that client is disadvantaged or there's a breach of the fiduciary obligation by the paraprofessional.
Thank you very much, Your Honor.
Thank you. Thank you, Justice Jimenez. All right, Dave, thank you for joining us again this week. Tell us a little bit about how this practice area will be treated in Arizona.
Well, the easiest thing for me to do and efficient is to say ditto. I think Dino's laid it out perfectly well. We don't have any different view at all from Dino. Now, let me explain maybe a little bit. You know, in Arizona, we already have 700 document preparers that have been practicing for 15 years. Now, they're able to do a very broad amount of work, but they can't give legal advice, although they can give legal information. And I have to admit that's a fairly gray line to draw. But it's interesting to Dino, to emphasize what Dino was saying, we get less complaints per capita on the document preparers than we do on our lawyers. And we rarely get a complaint from the consumer. Most of the complaints are lawyers saying the document preparer has gone too far in terms of their authority. So we're just not getting consumers after 15 years complaining about these document preparers. Now, we're creating a new tier. To be clear, they're not in operation yet. Our court's going to decide the rules in about 2 weeks. And if they authorize this new group, it's called a triple LP right now, and it's like a nurse practitioner. They will be able to go into court. They will represent clients. They will be able to give legal advice, but they'll do it in limited areas. So our areas are family law, our limited jurisdiction courts, and this, it covers both civil and criminal area, and administrative hearings. And so we're going a step further in some ways than maybe even Utah in terms of what they're authorized to do. Now in the debt collection area, we had our debt lawyers, our creditor bar at every meeting. They testified many times. I can't say we spent a lot of time on this unique question about cases going into federal law, but I'm completely in agreement with Dino. There's always going to be situations where, whether you're a document preparer or a triple LP, you have to say and advise your client, you need to get a lawyer who's able to do this, or a specialist, someone more skilled than they are. But that's even true for lawyers. We've got lawyers that take on cases they shouldn't be taking on. The other thing I can tell you, in Arizona, we have this unique situation. Like you, we already have 31 exemptions in our rules for non-lawyers to be able to practice in our courts. We've had those for years. But 50 years ago, our Supreme Court ruled that doing a normal real estate transaction, the conveyance of real estate, was the practice of law. Well, the real estate agents didn't agree with that, or I guess they agreed with it, but they didn't like it. So they did, like you, we have the initiative process. They got the signatures and modified our Constitution specifically to authorize non-lawyer real estate agents to practice real estate law. They've done it for 50 years, and we have no widespread problems in real estate. Now, my guess is most lawyers use real estate agents, non-lawyers. Now, if you're doing a complicated commercial transaction, you want to probably get a well-experienced commercial litigator or lawyer, a real estate lawyer, not a paraprofessional, not a real estate agent. So in our state, we know that non-lawyers can successfully practice in limited areas. And that's what our triple LP is going to be authorized to do.
Judge Yu?
Yes, thank you so much, both Mr. Byers and Justice Jimenez. My question is to each of you. In your jurisdictions, are paraprofessionals able to speak in court and represent litigants in the courtroom?
Yes, in Arizona, that is what we're going to authorize. Currently, our document preparers are not supposed to do that. But we did hear stories occasionally when they've gone to court at the request of their client to sit in the back of the room. Sometimes the judges actually have asked them to come up in front of the bar, sit next to the clients and answer questions. But that's not routine. That's not something to do. However, I will point out that a number of our document preparers are also certified to practice before IRS. And in those cases, so their practice may do family law and tax, say. In those cases, they do go in and represent clients before IRS. But in Arizona, the answer is yes. If our court approves the rules, these paraprofessionals will be able to go into court and represent clients.
So in our case, the answer, Ms. Yu, is currently no, but it's a no but. That is something that I anticipate will happen in short order. We're looking at expanding the ability of paraprofessionals to participate fully in court. We're looking at expanding the areas in which they can participate, and we're looking at expanding the groups of individuals who may participate as paraprofessionals or as legal professionals. I also need to clarify one thing to make clear. What I said earlier is my opinion. This question that you've asked today has not come up in Utah, to be perfectly blunt about it. And I'm giving you my opinion on how it would be resolved under the LPP structure we have. But our LPP structure, and I don't know what yours is, ours is very document driven. So what we've said in these particular areas, the LPP can offer advice that is based on approved documents. Now, these approved documents are meant to cover the waterfront in those three areas: landlord, tenant, family law, and debt collection, with some rare exceptions, like a quadro, right? But I don't know that they've actually approved the form that would deal with like a Fair Debt Collection Practices Act claim. It's just not a question we've actually heard yet. So to be perfectly honest about it.
Leah, can I follow up with another question?
Sure.
Okay, so for both Mr. Byers and Justice Jimenez, I think for us in California, you know, where there are people struggling to imagine what this will look like and what the ethical requirements will be for people who are paraprofessionals, the level of practice. And so I have, you know, in my courtroom, I see various different levels of practice from lawyers. And so I'm thinking that paraprofessionals will also have various different levels of practice. But to address the concern that has been raised that paraprofessionals will be less able, less smart, unable to learn the evidence code, unable to make objections, you know, make mistakes. What's your position, Justice Jimenez and Mr. Byers?
So again, it's not been borne out by the empirical data that we have in terms of non-solicitors and others representing these individuals. Anecdotally, we haven't completed the study of the program, which is underway. Anecdotally, that is not what I am hearing specifically from the Domestic Relations Commissioner that has the most experience with these individuals either. I mean, again, these are folks that my clients would have been far better off, rather than me doing a friend and family law divorce, Judge, having somebody with one of these individuals with 15 or 20 years of experience or specific training in the area, and that's all they do, than me handling them.
Thank you.
Yeah, Judge, our triple LPs are going to be under virtually the same ethical code as attorneys. They're going to become an adjunct member of the state bar. Discipline complaints will be handled in the exact same way by the same staff. So the bar discipline staff, investigators, prosecutors will handle a triple LP. All that will be the same. The other thing I'll do is I'll point you to, I think the best program to look at in North America is Ontario. They have had thousands of what they call them paralegals, but they're able to, unlike in America, they can practice on their own like a nurse practitioner. I think right now they have 4,000 or 5,000 of these licenses. They've had it for over 10 years. There's been at least 2 or 3 evaluations of them. I've spoken with them, their director, and they're regulated under the bar, the equivalent of the bar in Ontario. they confirmed that what Dino was saying, there has been, on the evaluations, no greater number or percentage of complaints, no difference in terms of the quality of practice from the consumer's point of view. And so when I got into this, I didn't know. When I was on our task force, I didn't really, I wasn't promoting one way or the other, but the more we explored it, the more we concluded exactly what Dina has said. There is no indication that a paraprofessional cannot do these jobs, perhaps though in limited areas.
Thank you.
Also, I would mention, you think we're going to have to wait to see what the federal courts do? I can tell you, our federal bankruptcy courts allow our licensed document preparers to charge and produce bankruptcy forms in our federal courts. Now, it's true, we don't allow the document preparers to go into federal court. But I guess over time, we'll have to wait and see whether the federal courts, the immigration court, would rather have paraprofessionals come in than nobody. And see, that's why we've got to keep our eye on that ball. This isn't a matter of, you're not going to get the Mercedes. 80% of the people coming out of our courts don't have lawyers anymore. It's civil, it's family. And so the judge's choice is a pro se litigant on their own or a paralegal. And our judges, by and far, are saying I'd rather have a paralegal come and help, take the emotion out of it if they're experienced. And of course, like everything, there'll be great paralegals, triple LPs, and there'll probably be some that won't be as great.
Thank you. I don't see any other subcommittee members with their hand up. Oh, Carolyn?
Oh, just really
yeah, Carolyn, sorry, okay.
Yeah, no, I just wanted to ask Mr. Byers about the same question about privilege and work product. Are those
just like Utah, it's going to extend to the triple LPs.
Does that extend now to the document preparers?
No, the document preparers have customers, not clients. So the client is always self-represented with the document preparers in our state.
Thank you.
For what it's worth, Ontario just barely released this week its 2020 report based on 2019. So its annual report on 2019 from the Law Society of Ontario came out, I think, 2 days ago. So
we'll get that to the group. Thank you. Julia, you're on mute.
Can you hear me now?
Yes.
Okay, great. Thank you both very much for coming. I have a question about the Utah jurisdiction and what is contemplated for Arizona with respect to E&O coverage or malpractice insurance for these paraprofessionals. Can you talk a little bit about that?
In Arizona, we're going to treat them just like we treat attorneys. And in our state right now, an attorney does not need malpractice insurance. So they have to disclose it to their client. And so we decided we can't treat them differently than attorneys. Now, there's always a debate going on, well, we should require attorneys to have malpractice insurance. And I think if we ever move there, then we would do the same thing with these paraprofessionals. I'll also tell you that they're going to be under the same client protection fund. So we're going to adjust our client protection fund trust. They'll pay into it, and their clients will be eligible, just like a lawyer, if there's theft of client monies.
In Utah also does not require lawyers to have insurance, and we haven't imposed any additional obligations on the paraprofessional. And I hate to keep coming back to the issue, but I have to be my OCD self for a minute and say, if this question about the scope of the paraprofessionals' work were to come before the Utah Supreme Court, what you've heard is kind of an off-the-cuff opinion, and I would keep an open mind. That's a Supreme Court justice response, by the way, for everyone.
So as a follow-up question, Justice Jimenez, thank you. I wanted to ask, if you don't require insurance, do you require the same as Arizona, that they have to disclose it to their clients?
I don't know the answer to that question, to be honest with you.
Okay, thank you.
Yeah.
In California, that is a requirement for attorneys.
I don't know for attorneys or paralegals, and I just don't know the answer. It's a great question, and one that before the night is through, I will know the answer to, but not right now.
And one other thing I'll point out, well, two things. Sometimes when we talk privately to lawyers, there is a lot of concern about competition and driving them out of the practice and so on. In Ontario, during the period, this 10-year period that the paralegals started, even though they have thousands of paralegals, they've added 10,000 additional attorneys in Ontario, and the billings are not down in Ontario. So it's another example where adding this paraprofessional category did not result in anything you can see in terms of economic loss or a lowering the number of attorneys in that state. The other thing, our state's going to also look at modifications to 5.4. In fact, we're going to proposing eliminating it. And if that's the case, a law firm, you can conceive of a law firm that has a highly qualified lawyer, say in this debit credit area, and then 2 or 3 triple LPs. And they can adjust their cases who does what based on the complexity and the activity. So maybe the paralegal, or not the paralegal, but the triple LP goes into court on the simple matters in state court. But if, in your example, you get to a federal issue, then the lawyer takes that case. So you could have a firm that would be broader than just all lawyers or just triple LPs.
Okay. Stephen Hamilton, I see you have your hand up, and then I'd like to go to our next presenters. Go ahead.
Mr. Byers just jumped the lead. Justice Simonis, are you seeing any of the paraprofessionals being employed by law firms and deployed in the way that Mr. Byers just laid out?
So we have just, I mean, it's been a year now with only 4, and I believe 3 of them are employed. We have 9 in the pipeline now. Utah's small, keep in mind. So we're looking at 20, I think, in the first 2 years, 210, if we don't change who's eligible. I suspect that within the next few months, we'll greatly expand the number of people that can become an LPP. But it's just too small of a sample size, Mr. Hamilton, to be able to give you data. I mean, that's nothing but anecdote at a sample size of that, okay, like that.
But some are employed with law firms as opposed to being an independent practice.
I believe 3 of the 4 are.
Okay, thank you.
Stephen, in Arizona, we haven't started our program yet, but I can tell you there was one lawyer on our task force who runs a family law practice, but then separately owns a document preparer practice. And under our old regulations, they had to keep them separate. She completely intends to merge them and add triple LPs. So we think it's coming. And then in Ontario, a substantial number of the paralegals also work for law firms.
Yeah, I think it's good to get those numbers because, and I'm speaking more from the family law perspective, but I think it'll apply here. I think that, you know, the most vociferous group that's going to oppose our recommendations is going to be the California Lawyers Association and any other attorney advocacy groups, and explaining to them, no, this is another method of delivering of service in that segment of potential clients that you could not service because you would be too expensive. This would create another avenue for providing service where you normally couldn't.
Yeah, while it's anecdotal, right? I believe that these people practicing in family law in Utah are charging $70 an hour.
Okay, thank you.
All right, thanks. Thank you both. Robert Hyde.
Yes.
You're up. Thanks for your patience.
Well, I've never been in any of these meetings with you guys, so I'm totally lost as to what's been going on in the past. Let me start by saying this. I'm an attorney in San Diego. I'm licensed in Minnesota. I teach law school down in San Diego, and the course that we teach in San Diego is consumer law. All we do is teach consumer law, and quite frankly, the reason we only teach consumer law is for the last 20 years, the only thing I've ever done is consumer law. I don't do divorces or anything else. Everything is consumer law. With all candor, this sounds like a terrible idea. And I'll tell you why. I deal with attorneys. We have a very significant law firm. We hire attorneys. It takes a long time to teach an attorney consumer law. It is not as simple as it sounds. It is not just a matter of going in and defending a consumer who who owes money. It's not that simple at all. In fact, the statutes all intertwine. That's where they become a real problem. You don't just go in, I mean, somebody doesn't call and say, well, we've got an FDCPA case, or in California, we have a law called the Rosenthal Act, which is a state version of the FDCPA case. They don't call and say, we have a Rosenthal case. They say, this is what's happening to me. I bought a car, I fell behind, a lawyer's calling me, debt collectors are calling me. I was telling Carolyn yesterday when I spoke to her on the phone, I had a case where a debt collector told a woman that if she didn't pay her bills, they were going to deport her children back to Mexico. I've had a woman who was told, if you can't pay your bills, literally told, if you can't pay your bills, you need to go out and start servicing men. All right, these are not simple cases. And if I sound defensive, it's probably because I am. I think that people don't recognize how significant these cases are and how much impact they have on consumers. And I think it does consumers a great deal of disservice when we say to them, your case is not so significant that we think it has to be handled by an attorney. We only, and in fact, I'll tell you, you call our office and you have a problem with a debt collector, you're speaking to an attorney. You're not speaking to a law clerk. You're not speaking to a legal assistant. You're speaking to an attorney. These are very complex cases. We have, I mean, you've got the Fair Debt Collection Practices Act, you got the Rosenthal Act, you got the Fair Credit Reporting Act, you got the Truth in Lending Act. All of these things work within each other. It is not just that you have a TILA case. It's, well, I think I got a debt collection case. Well, let's hear your case. Here's what it is. Oh, this is TILA too. This is, and they're secretly recording your phone call. That's a violation of the law as well. So, I mean, I think that the idea that this is kind of cookie cutter stuff that we can just put, and no disrespect to law clerks, but I've been doing this for 20 years. This is I have literally, not an exaggeration, done thousands of these cases. And the idea that these are just simple little cases that some law clerk can do is quite frankly, I find insulting, first of all, and silly. One question I would have is this. Most, and I think the judges here would tell you this, most of these statutes have fee shifting provisions in them. They have provisions in them that if you act in bad faith or you don't present your case appropriately, the consumer has to pay the attorney fees for the creditor. Are those going to be waived? Or are we just going to say, well, they made a mistake. They went with a law clerk. They didn't go with an attorney. They made an error in who they chose to represent them. The other thing is this, and I don't know how your experience is, but we charge no one anything unless we win. And I mean, to the point, we don't even charge a filing fee. If you come to us and say, this is what's going on, and we think there's a case, you're not going to have any trouble getting me to go to court with you. I will go to court with you. I will file it, and I will pay the filing fee. And if we lose, I will still pay the filing fee. And it's never happened, but if we get sanctioned, I will pay that as well. We do not assume that consumers can handle these themselves, and we certainly don't assume that legal assistants can handle them. So, I mean, the idea, you were talking about federal versus state court. I want to talk a little bit about that. Every case, 99% of the cases I've ever had, we file in federal court, not state court. And there's some good reasons for that. One good reason is if you sue in state court, then they can bring a counterclaim for the debt. I'm just talking about debt collection right now. They can bring a counterclaim for the debt. So what do you think happens? Let's say you take something, just a simple case, credit card case. Somebody's getting sued for $10,000 credit card case. They're being abused. We'll take this woman that was told, we're going to deport your children if you don't pay this bill. You want to go sue them. If you sue them in state court, first thing that happens is they're going to countersue, and next thing you know, you're having to pay those fees out of that. They're saying, well, okay, you owe $10,000, the debt, and but you violated the law, and there's $4,000 in statutory damages there, and there's a couple $1,000s for actual damages, and So we're going to offset it, and you're going to walk away with $4,000. That's the reason why we only sue in federal court, quite frankly, is because if you go to state court, we get hit with countersuits for the debt. So we never sue in state court. And those are the kinds of things we run into. And this whole sanctions issue, I think, is a very serious problem. I don't know what happens in Arizona or Utah, but I mean, do you excuse people who get sanctioned in those courts? Are we just saying because they don't have an attorney, they just took they rolled the dice and they took their chances? I mean, I don't understand this.
Okay. I think that was a question for maybe our Arizona and Utah folks, but I see several subcommittee members with their hands up. Stephen Fleischman and then Amos.
Mr. Hyde, thank you for coming.
Yes.
The goal of this is to close the justice gap, which is consumers in California not having access to the courts. My experience as a defense attorney is there's no shortage of plaintiffs' attorneys willing to take cases that have merit on a contingency basis, particularly when there are statutory fees. I looked just on Google, within 2 or 3 minutes, was able to find 10 law firms willing to take these kind of cases involving, the Rosenthal Act or the Fair Debt Collection Act. Down in San Diego, is there a shortage of attorneys willing to take these cases? And I assume they're all done on a contingency, right?
Well, it depends on what you're asking. I want to make sure are we talking about debt collection cases, the FDCPA cases? Or are we talking about suing somebody for a debt that they owe? Because then, plaintiff, defendant.
I'm talking about harassment by creditors or
okay. All right. I like those. We do a lot of those. Is there a shortage of attorneys like that? I wouldn't say that. I would say that there's somewhat of a shortage, but I think one reason there's a shortage is because a lot of people are just ignorant as to what they can do. In fact, I often tell people, I speak at conferences, and I often tell people the biggest problem we have is the consumers don't know what their rights are. It's not that there's not people there to help them. They just don't. They think they have no options. Like most consumers figure, I owe some money on a credit card. I didn't pay it. I guess I've had it. I'm not going to court. I can't win in court. And the truth is, you can win in court. You can win. You have a defense. There's all kinds of things that you can do, but you have to have somebody there that knows what they're doing. And a problem I'm having with this is I see it all the time. I've seen it for 20 years. I've been doing this. I think people really diminish consumer law. Consumer law is very complicated. It is not simply a case of going down to small claims court and defending somebody. And I'll tell you something else. I don't know what the statistics are for prevailing on lawsuits in family law and things like that. My experience with our firm is that we prevail in over 95% of the time. We win our cases. And the reason we win our cases, quite frankly, is we know what we're doing. We specialize. So yes, I agree that if we hand a credit card lawsuit over to somebody who does divorces on the side and things like that, I don't think we're doing a very good service to the consumer. But I also don't think we're doing much of a service for consumers when we pass them off to legal assistants who are just going to go down and, in most cases, let's be honest, they're going to go settle them. They're going to go down to court. The judge is going to say, I want you guys to go out in the hall, see if you can work this out. Next thing you know, they're just settling the case. They're just being debt collectors. Yes, go ahead, Your Honor.
Actually, I'm sorry. Justice,
I'm sorry.
Amos, he had his hand up next. I do want to, he's on the subcommittee. I want to allow him.
Right, I apologize. It'll be a few minutes.
Mr. Hyde, thank you for joining us. A couple questions.
Sure.
One, you mentioned you teach at law school consumer rights. I'm wondering, do you guys have a clinic? Do you use law students to train to help people with debt collection issues?
First off, we do teach in San Diego. We have done some clinics. Yes, we've done clinics. We don't get as much activity. One of the biggest problems, like I said earlier, is people don't know that there's people out there to help them. If you were to say to me, these consumers are having trouble finding attorneys, I would tell you it's not because they're not available to them. And it's certainly not that the laws are not available to them. It's more an exposure thing. Most from my experience, most consumers think, I've had it. The big shot attorneys are going to come in and they're going to run roughshod over me. And yeah, sure, I got a $10,000 debt and I can go out and spend $20,000 on an attorney to represent me on this. But, I mean, too many consumers don't know that there are things that can be done. And if somebody said to me, if you could wave your hand and change something in the area of consumer law, the one thing I would definitely change is I would want people to know what their rights are. And they don't know what their rights are.
So a follow-up question, Mr. Hyde. Thank you for that. So I'm wondering, in the clinic context or in the law firm context that you're talking about for consumer, particularly debt collection actions, I'm wondering, how much of that is pre-litigation? So somebody's being harassed by a debtor, somebody, that they can't pay, versus litigation, either affirmative litigation or defense of creditor claims. Because I think we are grappling with both. I think there's even been some discussion about, is the pre-litigation debt collection assisting with debt harassment or even fixing credit reports, is that even practice of law? I think I'd be interested in your experience, both pre-litigation and litigation.
Well, frankly, most of what we do is not pre-litigation. It's, but frankly, one way that we help defend consumers, let's say, it's easier if I use an example. You come to me and you've got a $10,000 debt again, and somebody's harassing you over it. Now, we can go to the creditor and try and work it out and things like that. But the truth is, there are so many other statutes that protect these consumers. We don't really need to do that. And we feel like we're doing a disservice. When I go to American Express and say, listen, I know my client owns $10,000. Let's see if we can work it out. Yeah, I mean, that happens. And sometimes it happens. In fact, I've got one guy who's real good at that. Sometimes I give him a hard time because he's a little too good at it. Because the truth is, American Express, if we look close enough, is probably violating the law, other laws. And we have no problem at all saying to American Express, well, I know my client owes $10,000, but you've been secretly recording his conversations. And in California, that's $5,000 per call. So the real question is, how much are you going to pay my client? Not how much is my client going to pay you? And we are very aggressive in that sense. Don't get me wrong. We're willing to settle. And a lot of clients want to settle. But what I'm really trying to say is this. In fact, even now, I got 20 years experience. I do not know everything there is to know in this area of law by any means. But I will tell you, there is so often I can use one area of law against another area of law. When somebody says your client owes money, and I can say it's back to them, yeah, well, I've heard that before, because when you called my client, you said to her, you need to go out servicing men. Okay. Now, law clerks don't know that. Law clerks don't know what to do with that. Or when they come back and accuse our client of doing something improper, and most of these statutes have fee shifting provisions in them. I will tell you, if I was a consumer, and I would not be very happy to find out that my law clerk that was working for me got me into trouble with the court, because there are sanctions for bad faith or improper purpose or things like that. So I guess what I'm trying to say is, yes, I understand. And I'm not quite, I'll be honest with you, maybe you can fill me in on this. What is the problem that you're trying to solve here? Is it you feel that people can't get access to attorneys? Is that what I'm hearing? Or?
So if you could just give it the time, Mr. Hyde, happy to send you information on the California Justice Gap study, sort of all of the years of background and some of the more recent data that's compelling this initiative. But we do have another speaker. We need to take public comment, and we need to give the group some
Okay, if you would give me 30 seconds, I would like to show you something. I thought about this when I was sitting here. Let me show you something.
Okay, while you're getting that,
I got it.
I see you
Okay.
have your hand up.
Right here. This is the FDCPA. This is what you want these clerks to know from a one semester class. There's two of them. Okay, this is just the FDCPA.
Leah, sir,
Yes.
this is Judge Yu. I'm a member of this committee, and I just think we need to move on. Thank you
Yeah.
so much for your comments. Leah?
Okay. Yes. So I see Justice Jimenez, if you could keep it very brief. Stephen, did you have a question, or should we lower your hand? Stephen Fleischman.
I have already asked my question of Mr. Hyde.
All right, great.
Thank you, Mr. Hyde.
Super short.
Yeah.
I think that I'm not sure that I disagree with Mr. Hyde on a lot of things. What's the limit for small claims in California?
Excuse me?
What, 10 grand? I mean, I think in Utah, these people in debt collection could only practice in small claims court. So I'm assuming that they've been able to bring these actions, these counterclaims in small claims, but they're limited to $11,000. I'm guessing that the types of cases that Mr. Hyde is talking about are no place near $11,000 claims. That we're talking about apples and oranges in these cases, that our paralegals wouldn't be able to come near these cases and would have to refer them to counsel to be.
I didn't realize you were talking only about small claims court, by the way, and I agree.
In Utah, I'm talking about what we've licensed, so to make sure that everybody's on the same page. In Utah, when it comes to debt collection, we're only talking about small claims. We're only talking about $11,000 or less, because otherwise the view was every contract case is a debt collection case.
Sure.
Okay. So Stephen, put your hand up, and then we're going to move to our last speaker, David.
Thank you. Justice Jimenez, real quick. In California, we have 3 levels of courts. Small claims is up to 10 grand. We have limited jurisdiction up to 25 grand. Unlimited jurisdiction, everything over that. As between small claims and limited jurisdiction, would your recommendation be limited to small claims, or would it be limited to limited jurisdiction?
I mean, honestly, I'd have to think about it and study it before my personal view is I want to expand the ability of these individuals to give service as broadly as possible because of the dearth of representation for most of defendants in these areas of law.
But
I can't give you a thoughtful answer without really knowing a lot more, Mr. Fleischman.
Would you be in favor of limiting it to one of those 2 lower level jurisdictions rather than unlimited, or you don't want to answer that either?
All I could say is in Utah, it's limited to small claims, and that is what it's been limited to.
Thank you.
All right. Thank you. David Kaminsky, thank you for your patience.
Hey, David. David's one of the guys we go up against a lot. Go ahead, David.
Yes. Hello, everybody, and I apologize. I'm in the midst of a little emergency right here. I've heard so many of the comments. I have to agree with a lot of the comments of Bob Hyde. They're in very short and brief. I believe that there are some matters that can be handled by paraprofessionals, but with the even some of the smaller debt collection defense cases that I handle under the FDCPA, the FCRA, the Telephone Consumer Protection Act, and the Electronic Funds Transfer Act, et cetera. Once we start getting into those cases, the level of sophistication and the level of argument just rises to an extraordinary level. Bob can tell you that there are some cases that his clients demand $12,000, and I can tell you some of those cases go to the Supreme Court of the United States, and they actually have, because there's such volatility. There's so much fighting by the defense bar because of what the implications are of these cases. Because if there's a particular case that rules in a certain way in New Jersey, let me tell you, that can spread all the way to California, and that could create a series of 10, 20, 30,000 lawsuits by different attorneys across the country. That's why it is so vigorously and so vehemently fought, and with such level of sophistication that so many of these cases go to the Circuit Court of Appeals and are ruled. And I'm talking about where there's a $3,000 demand. So that's why I think we have to work with extraordinary trepidation in order to determine which cases may or may not be appropriate for paraprofessionals to handle. And I can tell you that I haven't seen, I don't know, in my professional opinion so far, I can't think of any cases that where I think a paraprofessional could handle some of these cases in light of what happens. Maybe there's, I don't know. I'm struggling with this issue very much, and I've heard what everybody says, and I so respect what everybody says, but I'm struggling with this issue greatly.
Thank you. Do any subcommittee members have questions? That wraps up our formal presenters. So any last questions for any of our formal presenters? Did you raise your hand, Amos? Okay, Amos and Judge Yu, go ahead.
For our specialists on the call, I appreciate you coming and talking to us. One of the things we haven't specifically talked about on this call is automobile financial issues and car repossession. This is not lemon law type things, but I'm wondering, is there different types of laws that cover those issues that would warrant treating them differently or separately from representation of debtors in enforcement proceedings or harass or debt collection type actions that are specifically to the automobile financial issues?
Well, they are different for sure. There's still debt collection. I can't speak for every state, but I can tell you in California, the biggest problem we have with people repossessing motor vehicles is that these towing companies, these repo guys, and you turn on television, they take great pride in the fact that they go and they push people around and drag them out of their car and punch them in the nose and a million different things. I often tell people debt collectors are bad, but they're nothing compared to repossession agents. And unfortunately, in California, we have a law that pretty much exempts them from liability unless they do something extremely foolish. But yes, there's differences. There's differences. But then again, it's back to what I was saying earlier. A lot of laws interlace with them, and if you know those laws, sometimes you can use those to help your consumers in that area. So yes and no has been the answer, I would say.
Judge Yu?
Amos, did you want anyone else to answer that question?
Sorry.
Oh, I'm sorry. I don't want to jump in if you didn't feel like you got an answer from everybody.
No, please go ahead.
So my question is really to, let's see, is he still here? Justice Jimenez is still here, and Mr. Byers. And it's about your experience when you were developing your programs. Did you perceive that there was opposition? And if so, did you perceive as your programs were developed that people's concerns or skepticism fell away, or was it galvanized? What was your experience?
I can tell you in Arizona, because we watched the California experience and knew there would be significant opposition from attorneys. And we also looked at doctors years ago when nurse practitioners were suggested. It was the same thing. Doctors thought the world would end if nurse practitioners were allowed to. So we decided we certainly want to hear from our attorneys and listen to their views, but we set out to make sure we got views from non-attorneys. So we commissioned a statewide poll by a professional company of all adults in Arizona. We held town halls and invited community groups. And so we've got a mixture of comments over time. Eventually, our state bar endorsed their proposals, our state bar board of governors. But there were maybe 50 or 100 attorneys that wrote comments opposing the provisions. The public, though, on the polls, 80% of the public supported the creation of, I'll call it the nurse practitioner model, which was the same percentage of the vote when real estate agents went to the ballot. 80% of the citizens supported that. So I think what we have is the traditional tension. Those in a profession will oppose the change. It's a natural thing, and there's good points they make. But those out there seeking services have a different viewpoint. You got to try to hear from both.
Thank you.
Judge Yu, I'm sorry, I didn't catch the question.
Oh, I'm sorry, Justice Jimenez. My question is, in your experience in establishing your program in Utah, were there people who opposed your establishment of the program? And eventually with time, did those who spoke in opposition either come to support the program, as it sounds like in Utah that was the experience, or was their opposition just galvanized and it didn't change people's minds?
It was really very little opposition and remains the same. We were challenged by the legislature to do something about the access to justice gap. They appointed representatives. We had representatives from the family law section, the debt collection section, the landlord-tenant section, other experts in ethics, dean from the University of Utah Law School, others, to put the program together. And all along, Judge, I was expecting some galvanized effort at some point. It never happened. I mean, there are clearly there was some opposition in the comments, but you know, we're talking about 3 or 4 comments. I mean, when we did the diploma privilege in 1 week, we had almost 600 comments, right? When we ran this for 45 days, I think we had 3. I mean, just some small number. It just never got under people's skin in the same way that a lot of other initiatives have, for whatever reason.
Thank you both.
Thank you. Thank you for the chance to be here.
We appreciate it.
Is the committee ready? Oh, I see, Amos, you have your hand up, and then maybe we can, is that a new hand, Amos?
Yes,
we'll
thank you. I'll be brief, but I wanted to one quick follow-up question for Justice Jimenez. It sounds like you started the program in Utah somewhat narrowly with 3 practice areas, and now you're looking at expanding potentially into other practice areas. One of the things we're also considering here in California is which practice areas, and do we start, you know, focused on 1, 2, or 3, or do we start broadly with several different practice areas? And I'm wondering if you could share your experience in Utah.
You know, I think, Mr. Harston, we started narrowly, as you indicated, but we're rapidly looking at expanding, as I indicated earlier, looking at potentially like some criminal cases where you're not going into custody, similar, I believe, what Ontario can do. Expungements, perhaps expanding the jurisdiction for some of these, like the debt collection matters. I mean, going beyond what they can currently do now. Other areas. I have a fundamental problem with the enormity of the access to justice gap in the United States. The World Justice Institute just released its 2020 report. The United States, when it comes to access and affordability of civil justice, is 109th out of 128 countries, almost dead last in the world. We are dead last amongst the wealthy nations of the world in access and affordability of civil justice. And it's not just that study. I mean, your California study, Utah study, the LCS study, it's a gap that runs all the way up the socioeconomic pole, and then disproportionately affects people of color on top of it. It's sinful. I mean, something has to be done about it.
Okay. Thank you. We'll let you close us out on that note, and I'll move over to our public comment. I see 2, Stephanie Carroll.
I'm going to bow out at this time, if that's okay, Ms. Wilson.
Thank you so much, Dave. Justice Jimenez, I'm sorry for skipping over that. Thank you. I really appreciate it.
It's been our pleasure, I'm sure.
Mr. Hyde, thank you very much.
It sounds like you're not going to need me any further. Is that right?
That's right. You're free to listen in, but.
All right. No, I'll take off. Thank you very much.
Thank you.
Thank you.
Thank you.
Stephanie Carroll, has she been promoted? Go ahead. You have about 2 minutes, Stephanie.
Thank you. Sorry, it just booted me out for a moment. I hope you've all had, or committee members have had, the letter that I sent in. It's from Public Counsel, Housing and Economic Rights Advocates, East Bay Community Law Centre, Riverside Legal Aid, Elder Law and Advocacy, and Legal Aid San Diego. So I'm not going to go through all the points that I made in that letter, but there are a couple of things that came up in what the presenters were talking about that I would like to address. The first thing is, as you can probably tell, I'm English. I was a barrister in London, and I know the British system very well, and I want to make sure that we are not comparing apples and oranges here. In most British towns, you will find something called a Citizens Advice Bureau that provides free legal advice to everyone, regardless of their income. They are very, very skilled practitioners. They do, however, also have lawyers that they refer to who work with them, but the frontline staff are like paraprofessionals. They don't have audience rights in the courts of England, and they are 60% or more government funded. I would also like to point out that in England, you have civil legal aid to a certain extent. There are various, that is qualified by income, but there are various different types of civil legal aid available to people. You don't have anything like that in the system here in California, or indeed anywhere in the United States, as far as I'm aware. So I wanted to make those points. The second point I want to make is related to auto cases. There is indeed a lot of difference with auto cases. There is something in California called the Reese-Levering Act. Repossession is an extraordinary remedy, and in order to collect on deficiencies after repossession, you have to go through a very detailed statutory scheme, and you have to do it very exactly. And a lot of debt collectors of auto debts do not do that as exactly as they should, and those debts can be dismissed entirely. And that is a huge burden lifted off the shoulders of the individual. The last thing you want to do in a situation like that is negotiate some kind of payment deal when no payment is needed. So I really wanted to kind of put those out there. Public Counsel is the largest pro bono law firm in the nation. We were founded in 1970. We have over 130 people on staff. We have almost 100 lawyers. I have worked in the consumer law unit for almost 10 years. I have trained hundreds of volunteers who work under my supervision and under the supervision of my attorney to deliver free legal services. Forgive me, that was a good BBC interruption there. Every letter that goes out from my department is looked over by an attorney, as it should be. Now, we provide services to low-income people, and our services are entirely free. And I do want to echo what was said by Robert and Mr. Kaminsky. In terms of debt collection, cases are very complex and nuanced. It's not some kind of easy cookie cutter thing to do.
Ms. Carroll, if you could wrap up your
I shall. I'm nearly there. In California, almost all of these debt collection cases are filed in limited civil, not in small claims. We spend an awful lot of time, in addition to helping people for free, we help them clear up messes made by people who are either posing as lawyers or are offering to help, including bankruptcy petition preparers, notarios, etc. We have countless stories we can share with you, and I'm happy to do so. We would urge the committee to go very slowly with these proposals and to consult with all legal services throughout this process. My one final point is a lot of legal services funded organisations are not allowed just to comment or to do anything that is seen as lobbying. They need to be invited to comment on these proposals, and so I would urge the committee to reach out to all legal services funded organisations in California and ask them for their views on this and the types of areas that may be okay for paraprofessionals to work in, but litigating consumer debt cases, I urge you, is not one. Thank you.
Thank you. We have one more hand raised. Ira, if you could be brief in your comment. You've muted yourself. Are you?
I think it was Kaminsky.
No, I did see Ira with his hand up. I see you as well. I guess Ira took it down. Go ahead. Go ahead, Mr. Kaminsky.
Very, very short, 30 seconds. And I'm sorry this may have already been discussed, but as many of you know, most of these consumer collection cases get filed, most of these consumer collection cases get filed in the federal district courts, and the level of sophistication that you need with in the federal district courts, and the level of argument and the level of discussion, the motion practice, et cetera, that gets filed with respect to even, again, small cases is sometimes at an extraordinary level. And again, I don't know if it lends itself to paraprofessionals for that other reason. Thank you very much.
Go ahead, Ira. We can't hear you. You're on mute. Very good.
You can hear me now, I guess,
Yes.
as they say. I got 3 points. First, the Fair Debt Collection Practices Act is not 2 volumes long, it's 12 pages long. Secondly, it's not all that hard to defeat. In my personal experience, it's not very hard to defeat a debt claim. Here's an example. A client of mine on something else got sued on a credit card debt. They probably owed it. I filed an answer. I served discovery, which was formulaic, which was easy. And then they, of course, didn't respond very much. And I filed a motion to compel, which was also standard, formulaic. A paraprofessional could do it. They dropped the case. I've had that happen more than once. Thirdly, about the federal forum, I think that is not a consideration for debt defense. If a person being sued for a debt has a Fair Debt Collection Practices Act, the federal act, has a cause of action under that act, they can assert it as a counterclaim or cross-complaint. A counterclaim and cross-complaint is not grounds for removal to the federal court. So they would remain in the state court and litigate the case there. That's it.
Thank you. All right. Open the floor for the subcommittee to discuss. I think it was you, Carolyn, that mentioned, I'm sorry, the sun is in my eyes here. I think it was you, Carolyn, that mentioned that there were a couple of other outstanding issues, the repossession being one of them. We did kind of tee up the presenters to focus on what I thought was sort of the thorniest one for everybody, but happy to open, whatever. There are a couple, Linda, if you could remind us of the third. I think there are 3 outstanding issues for this group. But go ahead, Carolyn.
Oh, I was just going to ask Ira, did he leave? Oh, shoot. I was going to ask him a question. That's okay. I was just wondering, I didn't know that that the debtor could be sanctioned for or hit with attorney's fees if they lose. Is that, Amos, do you know that? Is that right?
And this is Fleischman. The answer is yes under most statutes. But it's like FEHA, Carolyn. It's got to be a frivolous claim. In other words, it's generally fee shifting one way in favor of the plaintiff, unless it's brought in bad faith, then the defendant can get their fees.
Okay.
Any other discussion? So Linda's put up on the screen.
I'm sorry. I know I'm really small now. I have my hand up.
Yeah,
about that. Thanks. I would think that if a person who is self-represented is on their own and not knowing what they do, it might be that they're going to make more mistakes and file something that's more frivolous, as opposed to having a paraprofessional or a lawyer help them and kind of sift through what is a legitimate claim and what is not.
Judge, you meant, you were way back when you told us that you had a pro se court in Santa Clara County. And could you remind us, or just again, are there any other counties that have ever done that? And what were, again, if you just remind us what your experiences were like?
So a while back, the court wanted to, the presiding judge wanted to have an experiment and have all the civil self-represented litigant cases go to one courtroom. And I said I would do it. And it was a great experience. I learned a lot. And so there was just, it's always better if somebody has a lawyer, I think, or a paraprofessional. Otherwise, they need to have a judge who's going to be patient and explain things to them, which is not always their experience. I'm not sure if every jurisdiction puts all their civil cases in one department, but I know that there are judges throughout the state who are handling cases in a civil context or family or et cetera, where the litigants are self-represented. After I did it for a year, the experiment didn't go forward because nobody else wanted to do it. I understand, but I thought it was a really good experience.
This is Steve. I came into this meeting skeptical that I would be in favor of including creditor collection agency harassment in the program. And substantively, I still am, but I was impressed by the speakers from out of state. But I think we have to listen to what they said very carefully, which is it's small claims court, and so far it's been 4 or 5 people. So maybe the way to compromise here is, if we're going to include it in the program, include it in small claims court or maybe limited jurisdiction. I think it certainly should be limited to the debtor side only, not the creditor side, like we did in general civil, Erica. And the federal issue still bothers me, but I guess the compromise there is you just have to make sure that there are adequate disclosures on that and that the client's okay with it. I was very surprised to hear that from the actual practitioners in California that 90+% of these cases are filed in federal court. That bothers me. So, if I had a straight up or down vote, I'd vote no, but interpret what I'm saying as trying to as a compromise proposal.
I have a question for Julia. Julia, I saw you perhaps shaking your head when Mr. Hyde was talking about his class, and I know you teach. So what are your thoughts on, and then Ira made that comment too. He's like, somebody's holding up these huge books, and then Ira's like, no, it's only 12 pages. You've been really quiet. What are your thoughts on how you would teach this particular area of material, these consumer things?
Well, I also had my hand raised, so I have a comment and I will answer that. First of all, my question or comment was going to be very similar to Stephen's and talk about let's maybe modify these to a more limited jurisdiction, or for example, small claims, because it seemed like that was an assumption that we were working with at least the justice from Utah. And once we see how Arizona votes and rolls this out, I think jurisdictionally it's a threshold issue. I think if we limit the idea of that, we're going to focus much more on the kinds of cases that we're really talking about. And so I'm with Fleshman on, let's maybe modify the subject matters to reflect that we are not talking about these kind of very large and complex cases. Now, with respect to Carolyn's question of me, the reason I shook my head is because, we do have our electives, which are taught in an ABA-approved paralegal program, and they are 1 semester long. But the program itself, especially if you are whizzing through it, you can complete it in approximately 2 years. Now that we are going to have classes cut, this will probably go back to how we were a few years ago, and it's going to be problematic to get all the classes that you want within a 2-year period of time. So my point is, I think when we get to the point where we're talking about licensing and things like that, we may want to make sure that we're maybe starting out, either with a paralegal graduate or a law school graduate, and then add on to whatever else education we're going to want to give them. But the biggest thing that we have to remember is that I presumed, or at least considered, that we were looking to find a niche for someone that was at least a paralegal or a law school graduate. And so they are going to have significant training under their belt already. And I mean, we may even want to require an AB approved paralegal program, which I teach in, which is much more rigorous than other schools that are not ABA approved. But I don't see this as being a one semester of anything. I think once we get our subject matters solidified and we coalesce around the idea of this is what we want to do as a pilot program, whether it's just, to be honest, I say we should probably start with a couple areas, just because I do think it's going to be very expensive to monitor, which, as I understand it, was one of the problems with the Washington program and why they wanted to close it down, because of the limited membership and the amount of money they had spent trying to supervise and educate and license this group. So that should be a consideration later, I think, for the whole group. But my other contribution that I wanted to make was, I think it would be really helpful if we can continue to have speakers that come from programs, so we're not reinventing the wheel. And when we talk about specific subject matters in particular, and I just think the idea for me, and maybe I'm incorrect in my assumption, and maybe it's just that an assumption, but I was looking at our goal in creating a paraprofessional career, that it would be someone at least a paralegal and or law school graduate and not a licensed attorney, and they would fit somewhere in the middle. But I would consider we are dealing with paraprofessionals or law school graduates who have already had a considerable legal education by the time they apply for this program. That's what I was presuming.
Amos?
Thank you. So I somewhat agree with many of these comments. I think there's two different things though, and we've sort of compartmentalized them. I think we do need to spend some time on what education and training is necessary and appropriate, and consumer protections. My understanding is that's not what is on the agenda for right now, and we're talking about which practice areas and which tasks may be appropriate, but I agree that they are certainly related, and whatever we approve, we also need to make sure there's sufficient and appropriate training and consumer protections built in. With that said, I think the complexity is a double-edged sword. Many people are saying this is a complex area, so it's not appropriate for a paraprofessional program. I think the complexity is one of the reasons why a paraprofessional program might be so critical to fill the justice gap for people who don't have attorneys, because pro se people who are trying to navigate it without assistance is really difficult. And I think we're going to hear the same things in the family law space. So family law, also I think most family law practitioners will say their practice area is misunderstood, is actually very complicated, and there's a lot at risk in those cases. But family law and debt collection, I think, with their complexities, one of the reasons why, if the benchmark is choose between having a attorney who specializes in the area or having a non-attorney, that's one question. But what we're really asking is for people who, for whatever reason, don't have access to an attorney, are they better off without an attorney and without any help? Or does it make sense if we have a program with appropriate training, with appropriate licensure, with consumer protections, is there space for a paraprofessional program? And I think consumer debt and probably family law are probably the two most obvious choices, even though both areas do have complexities. And we have to work that through in the, I hope we spend enough time carving out time to talk about consumer protections and training and licensure issues.
Amos, what are your thoughts on the jurisdictional question I raised?
Yeah, so I'm not a specialist in this area so I can't really speak, and I defer to some of our speakers. But my understanding is a lot of this happens in the state court level.
I'm sorry, I meant in-state court, limiting it to small claims or limited jurisdiction.
Yeah, so I definitely don't think we should limit it to small claims. Small claims is no attorneys or professionals are allowed at all. Limited jurisdiction might make sense. So that limit right now is $25,000. There may be some reasonable basis to limit it to limited civil jurisdiction. I actually think there might be reasons to raise that limit. I don't know if the Supreme Court's going to take that up, but there might be reasons that that limit should actually be higher. And I don't know.
Call me and I'll explain to you why that's never going to happen.
No, don't call.
Yeah.
But yeah, I would be open to a potential limitation to limited civil jurisdiction.
I just was asking, does anybody know?
I'm sorry, Stephen Hamilton is having that.
Yeah. Sorry, Steve.
I kind of want to echo what Amos was saying. We thought that we needed to define the practice scope before we went over regulation and licensure. The more we get into this, and this was coming up for me in family law too this week, I actually think we need to know more information about security funds, licensure, to use that to help define what we're going to recommend the paraprofessionals do. Leah, can we get the stats on how much money's in the trust fund for client claims and figure out how much of each year are we paying in dues for that? Because I think we need to know what we can fund for a paraprofessional client trust fund. That will help guide me in how big a scope I would recommend, at least.
Sure, and we're putting on the agenda for the 25th a discussion of the sequencing because this issue has come up. Maybe it's time to revisit, and so we're putting that on the agenda for the working group to discuss as a whole.
Okay, good. But we could get those numbers before, figure out what are we paying each year. I mean, I assume I could pull my bar dues.
Yeah, the base was 40 before there was a one-time increase. I can't believe I can't remember this because I worked really hard for it, but there was one time and a portion was permanent and I can't remember. So so that's where we are. Carolyn, sorry. And then
Steve. No, I put it in the chat really quick. I was just wondering, I know there's statistics kept on whether, from the civil cover sheet on how much creditor cases are found. Maybe we could get that breakdown, and maybe that is something we have to ask the Judicial Council for?
You mean in limited civil?
Well, I guess you would have to.
Unlimited?
Yeah, for these kinds of issues.
Yeah, I
check boxes.
Have that. We'll look. Steve Fleischman?
Well, I was responding to Steve Hamilton's comment, and maybe we'll deal with this later, but Steve, one problem I have with this is if we're going to create paraprofessionals and the regulation by the state bar, that they should be funding themselves and the lawyers shouldn't be taxed to fund the paraprofessionals.
No, agreed. I'm saying that's got to be considered as how much money would they have to pay to sufficiently fund their own trust. They shouldn't.
Okay,
I'm
you and
not
I are on the same
lawyers subsidize them. I'm saying what kind of money would they invest? Because how quickly could they build up a trust fund? Could there be some kind of group policy that's purchased? Would lawyers mutually agree to provide some kind of coverage on a temporary basis at a reduced rate or something to do to make sure that consumers are protected? Because again, the more protection there are for consumers, the broader I think we can define the scope of duties. If we find out that they can't sufficiently fund a trust account in short order, then I'm going to be, at least from my personal opinion, more restrictive in what I think that they should be able to offer in services.
This is Erica. Oh, sorry, Julia.
Yeah, and it's 6:31. So why don't we have a couple more comments and then figure out where you all want to go next. Julia?
Yes, I guess the thing that I wanted to say was, again, reiterate, I think that it would be helpful to get statistics from California, but I also think it was really instructive for me to read the basis why Washington had to suspend its program and look at the cost issues in other programs before we just start sending around numbers in a vacuum. I think really looking at these models and giving all of our membership of this committee models to look at with respect to licensing, insurance, and all that would be very helpful at the appropriate time. But I also think if in fact we have not done so already, I can't remember if there's a chart that we have comparing the triple LTs or triple L triple Ps or whatever in the different jurisdictions. I think it would be very helpful to look at what each one has in a graph format so we can look at the subject matters that are in each place that have already done this part of the work, and we can maybe learn from their deliberations.
That is in your Dropbox, but we can certainly send it around also.
Perfect, thank you.
I think the opportunity to make my comment will come around again, so I can hold it for another day.
Okay, so in terms of our next meeting, what we could do to try to, well, first of all, I think you all were coalescing maybe around limited jurisdiction for these claims, but maybe not quite ready to go there. There's been some data requests, even with respect to the filing small claims, limited, unlimited civil for these case types. We have these outstanding other issues, the car repossession, wage garnishment. What would you like us to bring forward for the next call?
Can I ask, do we think that we have a coalesced opinion or some consensus about limited jurisdiction? And should we make that decision now so that we're kind of honing in on a more concrete agreement?
I think that makes sense. I don't think I'm ready on car repossession or wage garnishment and would like to hear more about that. But I think with respect to representation of debtors and enforcement of judgment proceedings and debt collection and the creditor collection agency harassment, I think we've probably heard what we needed to hear. And it's all fresh in our mind. So if we have time to take a position on that, I think I would be in favor of that.
Does somebody want to make a motion? I think.
It was my idea. I'll make the motion. My motion would be for the remaining consumer debt practice area topics, the 4 of them, that it be limited to representation of debtors and limited to limited jurisdiction court. I don't know why we can't include small claims court in that, but if small claims is off the table, then I'm fine limiting it to limited jurisdiction.
I have order, Steve.
I'm sorry?
What do you mean by limited court? I don't think we've ever talked about that. I think we're all talking about pre-litigation. It's the first time I've heard anybody talk about court.
I don't think so. I think today was focused on allowing paraprofessionals to represent debtors bringing actions under the state Rosenthal Act.
Wow.
Or collection agency harassment.
Oh, I had no idea we were talking about that at all. Maybe I'm blind or deaf or something, but no, I can't. I would absolutely have to vote no on that. I had no idea that's what we were talking about.
Well, substantively, I'm against that also, but what I proposed was a compromise, and it's 6:36, so I don't think, and the answer to Erica's question is I don't think we have consensus, and I'm happy to defer that to next time. But Carolyn, so you understand, and Ira had a similar question, in general civil, we recommended that paraprofessionals be permitted to represent debtors in run-of-the-mill collection actions. So credit card company sues for $12,000 in debt, the paraprofessional would be able to do that. I wasn't in favor of it. It was a compromise. Originally, that was limited to limited jurisdiction, and then Erica wanted it out. I kind of want it back in.
Well, this is just the funneling process. Remember, we're not making any final decisions on our
Yeah.
recommendations.
And I don't want to waste anybody's time because, yeah, we are going over. But I guess, yeah, I was trying to understand and be part of that general civil. I wasn't, and I didn't and couldn't. And that was sort of why here I am now again. It's like 7 minutes over. I don't know. I think we need to talk about this a lot more.
Okay, but so Leah, why don't you, for the next meeting, pull together the general civil recommendations and we can.
I've read them. I just didn't understand them to be that.
Julia had her hand up.
We had a motion by Stephen Fleischman. Do we have
I withdraw the motion.
Okay.
I'm withdrawing the motion.
After Julia speaks, I'll make a motion. Julia?
Okay.
Yes, I would say I don't think we're ready for that motion until after we have the other subject matter experts come and hear what we're going to hear about car repossession, wage garnishment, and utilities. I think once we have a sense of hearing from each one of these, I mean, I don't think there is a consensus yet on the creditor collection. And since we're over already, I think we'll all stay very fresh in our minds. Plus this is being recorded should we want to revisit it. But I think at this point, it may feel hurried to take a vote.
Okay, but can I just try to see if we can push one thing through the funnel? So my motion is that what's remaining on the creditor collection agency harassment issues be pushed through the funnel as long as those cases are within the limited jurisdiction and the person receiving the paraprofessional services is the debtor.
I'll second that.
Okay, Linda, can you take the roll?
Yes. One moment. I have to pull that document up. Sorry.
Erica, I'm just giving you a heads up. I'm gonna want to revisit the general civil recommendation on that.
We're just pushing things through the funnel.
I understand.
So, okay. Brynildson,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Shining,
No.
and Judge Yu.
Yes, thank you, Linda.
Okay.
I really, you guys, I really wish we had more time to think through these resolutions. I just don't know why
Bye, everybody. Take care.
Wait, I have a procedure. Wait, Linda.
Yes, for the next meeting, you want us to try to bring forward people on car repossession, wage garnishment, utility shut-off was very difficult to find somebody, or are you just ready to have a discussion about the remaining topics?
I found it helpful today to have people, especially from other jurisdictions where
Yeah, I am concerned that the car repossession might raise different issues, so I think it would be helpful to get more information on that.
Okay.
I agree.
Fleischman, you're in. Go ahead.
I have a procedural point. Leah and Linda, you guys are doing yeoman's work. You're doing a great job. But we got that letter today from public counsel where I think they made a fair point that the content of the agendas are rather sparse and they're not sure what they're commenting on. So I would ask in the future if you could make the public agendas a little more detailed, time permitting, so that when we get public comments, they can provide more details.
Okay.
I thought that was a fair point they raised.
I think it is. It is a bit of a balance because we want to give you the opportunity to, move things forward, even if it's not specifically delineated on the agenda. So that's the challenge, but it is certainly a fair point. Okay, I think we've got our marching orders for the next meeting. Thank you all so much.
Bye, everyone. Take care.
Bye.
Bye. Thank you.